the things we're going to talk a little bit about. We're going to talk about a choice of entity for, as I mentioned earlier, for profits. Then we'll talk about benefit and B corporations, and we'll talk about nonprofit corporations, because there's a lot more interest these days about should I be a nonprofit? Shouldn't I be a nonprofit? What does it take? What does that mean? So we'll talk a bit about that. We'll talk about founder arrangements. What are the founders? What should we worry about with the founders, their IP or otherwise? How are they going to split the pie among the founders? Should they vest? Shouldn't they vest? What restricted covenants should we impose on them? We'll talk about operating the entity. And we'll talk about employee equity, because people were interested in, should they give the employees equity? Shouldn't they? What should the form of that be? So we'll talk a little bit about that. So that's the things we're going to talk about, but I'm happy to talk about other stuff if you want as well. And there are a lot of choices. These are the choices. I'm not going to go through all of them as it relates to the kinds of businesses that you can form for startups and for growth companies. We're going to focus. I'm going to focus the first part of this mostly on C Corps, S Corps, and limited liability companies. Then Odette and Stephanie will talk a bit about benefit and B corporations, with Cordy picking up with nonprofits thereafter. And let me just do a little nomenclature to start, for which I apologize. But and some of this, I apologize. The lawyers heard some of this and know it, and the law students and perhaps the corporate folks, the business people do too. But it bears repeating. Let me first get the words. Corporations, the owners of corporations are shareholders. So they are they're the owners. Then there's a corporation. The corporation is managed by the board of directors. So the shareholders appoint the directors, and the directors appoint officers who then implement. So shareholders own, they make decisions regarding sort of fundamental decisions regarding the company, the corporation, and they appoint the directors. The directors make strategic decisions like how much debt we have and whether we issue stock and all those kinds of things. And then they appoint the officers and directors who do the day-to-day. That's nomenclature that we're sort of accustomed to. On the limited liability company side, same structure, but just a little different names. The owners are called members, and the managers are called the people running it. Instead of a board of directors, you have a board of managers, and then you can have officers in the LLC too. So members instead of shareholders, board of managers as opposed to board of directors. I hear the question all the time: should I be a C Corp, LLC, or a S corporation? And here's the answer that is our favorite, which is it depends. And so we're going to talk about what it depends on. And I can tell you with 100% certainty that by and large I am usually wrong when I make this decision in 2020 hindsight, but I have an answer for that too. So we'll get to that at the end. For the first thing we're going to talk about is why form an entity in the first place. And the principal reason is to limit liability. And so I want to spend a moment on that because that's really important. We form an entity because the good news is that the owners, I just described them as shareholders or members, are not liable for the debts or obligations of that entity. So if I put $1,000 into the company and there's somebody sues the company, the good news is it can't go after me individually. It can only go after what's in that company. And that's sort of interesting, right? I mean, that's sort of it's an interesting concept. It's a rule of the game, and the world doesn't have to work that way, but it does. And so and I analogize it to when I go to play blackjack and I lose, as I always do. The good news is that the amount that I've put on the table, and I've put on the table is to wage. That's as much as I can lose. And what the dealer can never ever do is reach into my pocket and take more than I put on the table, because I'm limited to what my liability is limited to that which I've put on the table. And similarly, in a corporation, when I form a corporation, I can't be liable for the debts and obligations of it. So that's kind of cool. Now, it's important, essential that you adhere to the corporate formalities, because if you don't do that, then somebody what's called pierce the corporate veil, which is say, hey, there wasn't really a corporation. You didn't really treat it as a corporation, and therefore I'm gonna go after you individually because that was really a fake. So how do you keep it from piercing the corporate veil? Well, you adhere to the corporate formalities. You have bank accounts, you sign things as an officer of the company, you keep minutes of the shareholder or member meetings and the board meetings. You keep separate stock books. You do all the things to set up a corporation and adhere to the corporate formalities of it. And I've been in lawsuits where people have tried to pierce it, and they do all the discovery, and they find all those records, and they look for places that you didn't do this. So it's really important to go through. It sounds very formalistic and it sounds like kind of dorky, but it's really important. I'll put one other. It's these things that I'm suggesting here aren't just for that purpose. They also will help you create a record, which will be helpful when you attract capital or you sell the company. It's really important. On the stock record, by the way, I've noticed over the last few years how important it is to. There are easy ways. There are electronic systems, CARTA or otherwise, that you can keep your stock book and non-paper certificates. And it's just so nice to have that all in easily accessible and things. So it's both for the adhering corporate for avoiding having the piercing the corporate veil, but it's also just a good record keeping to have for as you move forward with your company. So why am I harping on this? Because I want to make sure that you aren't liable for that. Let me go to the last bulletin on this as well. I've talked about how you're limiting your liability, but there are some things for which you are liable. If you don't pay employees or you don't pay withholding tax, you could be personally liable for that. If you sign personal guarantees, you're going to be personally liable for that. So even though if you go lease some space and the landlord says, there's no assets here, why am I going to lease the space to you? I want you to sign a personal guarantee. You just signed a personal guarantee. Now you're liable for that. If you do an SBA loan, and you have to sign on the SBA loan, you're personally liable for this. Why do I harp on those two? Because I have a client right now who's in trouble. They're going to declare bankruptcy, but they're going to be personally liable on the SBA loan. The other thing they're going to be personally liable on is the credit cards that they put in their own names. So if they use personal credit cards, guess what? They're going to be liable for that too. So we go through this effort of creating this corporation, limiting liability, but these are things that you're going to be personally liable for. I have that next to the last bullet, pass-through entities. We're going to talk about LLCs. It's possible that one could end up with tax for through a limited liability company, but we'll deal with that when we get there. So that deals with personal liability vis-a-vis the entity. There are ways to minimize the liability of the entity, and the two that are there are contractual limitations and insurance. I mean, you do want to pay attention to what insurance you carry, so that, for example, if somebody slips and falls on your steps, it'd be nice to have insurance rather than have to pay the greedy plaintiff's lawyer, otherwise known as Edgar Snyder. Just joking. And you want to limit the liability contractually, right? So you want to limit. So if I'm entering into a contract, I can limit my liability under that contract. So this is another way to limit liability of the entity. Okay, so that's why one of the major reasons I form an entity is to limit liability. So that's why I hang on that for a little bit. Excuse me. I have a cold, so if I cough in here, I apologize. When I think about which entity to form, whether it's be a C-Corp or an LLC or an S-Corp, I'm sorry, I apologize. We're going to spend a moment on tax. And so, it is what it is. Things are, one has to pay attention to tax in this. And one of the things is corporations, C corporations are taxed, result in double taxation. And that's pretty important. And what I mean by that is that if I have a C corporation and it makes money, the corporation has to pay tax. And then when it takes the dividends money out to the shareholders, they have to pay tax. That's a double tax. And a limited liability company or an S corporation, with some of those exceptions, don't pay tax. The corporation or the entity the limited liability company does not pay tax. Rather, it passes through to the owner, whether it be the shareholder or the member, and they pay tax on it directly. So it goes right on their tax return. So there's no tax at the corporate level. Let me show you an example. If assume that our entity, whether it be the corporation, limited liability company, or S corporation, earns $100. On the C-Corp, the corporation will pay the corporate tax of 21%. These numbers will change next year. I can't tell you exactly what those rates are going to be, but I can tell you they're going to go up, not down. The relative between individual and corporate will have some impact on this result, but the end result will be the same. It just the order of magnitude will different based upon what the relative rates of individual versus corporate is. But this will give you the concept. If the corporation makes $100, the corporation has a 21% tax rate that pays tax at $21. It pays, oops, how did I do that? 1 second, going back. There we go. So if the corporation pays tax of 21% of $21, that leaves $79. Then it sends that out to the shareholder. Shareholder pays capital gain rates on it, I assume, of $16. So that leaves $63 net for the individual shareholder, corporate rate and the individual rate. Now take my LLC, $100, no corporate tax, zero, my favorite tax rate. So then it sends out $20 that pays the capital gain on the $100, $20, $80. So the owner ends up with $80 rather than $63. Well, that's pretty different, right? And if I add a bunch of zeros to that, that's a big difference. So if I'm selling the company, for example, and if I could put $8 million rather than $6.3 million, $80 million rather than $63 million, that's a big difference. So that's single versus double layer of tax, really important. And so one might think about that if one's that's a benefit to a limited liability company. On the other hand, because that's what lawyers do, they do the one hand and on the other hand, there's something called the qualified small business exclusion credit under the infamous section 1202 of the Internal Revenue Code. And what this says is that certain capital gains, now it only applies to C corporations. So the benefit I just talked about a moment ago was the limited liability company. This is C corps. And if I buy this stock and I hold this stock for more than 5 years in a C corporation, and and certain businesses are excluded, described there. I'm not going to read them off to you, but there they are. It's here. Then I can exclude today or yesterday. I could exclude that gain when I sell that stock. Guess how much? 100% exclusion. I don't pay any federal capital gains tax up to, I'm sorry, there's a $10 million capital. So it's only the first $10 million of gain. Okay, but that's $10 million of exclusion. And Odette and I just had a client that we just sold their business a couple months ago. They had taken their stock and transferred it to a couple trusts. So they had 4 different trusts. So it actually have 5 different shareholders. They excluded $50 million of gain. That's $50 million that they didn't pay tax on. That's pretty cool. So now in the new tax law that they're working on, there will be some carve back on this. Right now, the latest proposal is to reduce that 100% exclusion to 50%. So maybe it may not be as beneficial as it was, but that's still pretty good. So the point is that one possibility for a tax reason, a benefit to a C corporation, is this 1202 exclusion. You can also merge corporations freebie as well in a tax-free manner, so that's good. So those are some tax considerations that one thinks about. There's also the S corporations, limited liability companies can have the pass-through treatment. S corporations can also have that tax-free treatment, but it has some limitations that limited liability companies don't have. You're going to have one class of stock. There's a limitation number of shareholders. There's a limitation on the types of shareholders you have. Most of our clients, if you're called a lifestyle company, you probably, and you're going to raise money from third parties, an S corporation isn't really a choice. If on the other hand, you're you're going to be 1 or 2 shareholders, then you might consider an S corporation, which has that tax benefit I was just describing, but that flows through. There are non-tax, turns out not everything's about tax. And so there are some non-tax reasons for certain types of entities. For example, if venture capitalists will not invest in LLCs, they'll only invest in C-Corps. And there's a variety of reasons for that. But the point is, if you're going to end up with venture capitalists, then as investors, you probably want to be, you need to be a C corporation. If you're going to be an IPO, you need to be a C corporation. You can't IPO for a limited liability company. Sometimes corporations are a little easier to do option pools, and you can get incentive stock options that you can't get with LLCs. You can do it in a C corp. So there's some employee equity reasons where you might consider the corporation. I said earlier that I'm always wrong, which is not a great sales pitch. But 2020 hindsight, it feels like I'm always wrong. When in doubt, it's relatively easy to go from an LLC, a limited liability company, to a C corporation. That can be done in a relatively tax efficient manner, which is a euphemism for you can do it tax free. Having said that, going from a C corp, thou shalt never go from a C corp to a limited liability company, because that's not tax free. You got to pay tax. So when I convert from a C corporation to a limited liability company, I got to pay the tax man some money. What that means is if I'm in doubt as to which is better, I'm better off to start with a limited liability company and convert to a C corporation rather than start from a C corporation and convert to a limited liability company. So that's my default if that happens. So answer, no simple answer. If you're a lifestyle company and you're going to consider significant dividends or distributions, for example, if you're going to be a life science company and you're going to make money through doing licenses, so not waiting for some big bang, but you're going to do some licenses along the way, then you might consider an S corporation or an LLC. If you're going to do a venture capital oriented company, you ought to be a C corporation. If you're going to build it and sell it over up to 5 years, consider the C corporation so I can get that 1202. And remember, when in doubt, go from an LLC to a C corp. Don't go from a C corp to an LLC.
So, David, we have a question in chat.
Yes.
Why is Delaware C corp particularly popular among startups?
Well, Delaware, those are two different questions in one. I love it. Why Delaware and why C corp? Delaware because everybody likes Delaware. It's a lovely state. Biden's from Delaware. No, it has built up. Delaware has the benefit of a huge amount of case law and law relating to corporations, so it's predictable. People understand Delaware law, so investors and people are comfortable with Delaware law. So people have migrated to Delaware because VCs will invest in Delaware corporations. They're comfortable with it. So it sounds ridiculous, but it's in large part because everybody does it. And so there's an entire little cottage industry risen out of Delaware that's favorable toward corporations. And so it's a favorable place to go. So that's the short version why Delaware. The C Corp, people go to C Corp if you're going to, as I say, going to be a venture capital backed, going to raise additional capital, going to be or looking for the 1202. Those are the principal reasons. Other questions before I move on?
Nope. The questioner said thank you.
Cool. All right.
David, I'll pose a question for you. So if you're going to be an LLC, do you typically recommend a particular state if a startup decided to organize as an LLC?
If that's a good question. If you're going to if you're going to raise capital, even as an LLC, I'd still think about Delaware. If, on the other hand, you're going to be sort of I don't want to use the word lifestyle, but you're going to be self-funded, and you're going to be principally located in one jurisdiction, then I would stay in that jurisdiction. So, for example, if I'm not going to raise capital by third parties and I'm going to do business primarily in Pennsylvania, I would form a Pennsylvania limited liability company because there's no real good reason to go to Delaware. Okay. All right. Benefit corporations. Who wants to take the lead? Stephanie, Oded?
Stephanie she's very enthusiastic about the topic. Maybe she should bring at least give the introductory part.
All right. Well, we talked a little bit with my law students earlier today. Benefit corporations have grown up, but probably the last 20 years, Odette. I'm trying to think when they were first suggested. So as a way, a particular corporate form for social enterprises, which are these double bottom line companies that have both a financial bottom line and a mission-based bottom line. In some cases, they say they're triple bottom line because they also take environmental sustainability into account. They are, companies like Ben & Jerry's, Patagonia, Kickstarter, and then the local company that is not started in Pittsburgh, but is certainly an international company is Thread International, which is one of Oded's clients and can certainly talk more about their particular experience. I mean, the difference, as it says here, is, you have certain obligations under state law that are specific to benefit corporations to operate in a responsible and sustainable manner. Corporate directors and officers have affirmative duties to uphold that. It is now benefit corporations in 38 states. When this movement started, there were a number of different kinds of entities for social enterprises. Pretty much benefit corporations are the standard in most states now. They can be organized either as effectively as a C corporation or an LLC or S corporation, so that you can have the tax advantages of being, either organized as a corporation or a limited liability company. So Oded, you want to take it from here?
Sure. Sorry. So our favorite actually benefit corp is Stephanie mentioned is Thread, and what they're doing is basically they're collecting plastic bottles in places like Haiti and other places. They convert it into fabric, which is then sold or made the fabric that is sold as part of, for example, Puma in their shoes and other companies. When they use the title or name of what's called the first mile, which talks about helping the environment and doing it in a certain way, a sustainable way. So the main reason for them to do that, it's not corporate, it's not legal, it's promotion, marketing reason. They believe that they want to help the environment, and they use it as a marketing tool. So it involves these two items. Other companies can think about, for example, about social impact. A client came to me a few months ago and was talking about investing in distressed properties in the North Hills, for example. So we discussed the possibility of forming a benefit corporation. It does not have any tax benefits. It can be taxed either as a C-Corp or as a partnership. It can be taxed just like any other entity that you have. So there is no legal differentiator between the two. If we could.
Odette, I have a question. So traditional companies, C-Corps, LLCs, are literally, I think, sort of they're legally or fiduciary responsible. They have to make decisions that's based upon what's best for the company. And usually that means bottom line, as long as it's not illegal or immoral, whatever. Does this give a different responsibility of fiduciary?
Yes. So the corporation, GMs of the world, all they need to do in life is make profits for the shareholders. That's their job. And that's the responsibility of the management. They may have some other things to take into account, but in general, their whole purpose in life is to maximize profits for the shareholders. Now, if GM would like to take a big undertaking to invest in specific communities and other things, it cannot do that. They can do it in a very limited way because they're forbidden. They will be breaching their fiduciary duties to the public. I'm not saying that they're not doing it, but they may be potentially on the hook for that. So that's exactly why we created, or people created, this benefit corporation. So they will be protecting the board of managers or board of directors in their decision-making process and give them the right actually to consider other things, and also require them, not only that, they have to report back to the shareholders every year or every second year. I did X, Y, Z in order to improve my or achieve my goals in life, which were defined in the certificate of incorporation. So they have to report back that they actually did and try to achieve the purposes of the company. So if we can skip to the next page, the main advantage that we have in this is it's a marketing tool. Now, it's not good for every company. It's good for companies like Thread or other companies, the company, for example, that invests in distressed properties in the North Hills. And it's a marketing tool to the public. Not only that, it can attract specific investors. And Stephanie is involved all the time with even VCs that are involved in impact investments. And I'm personally, me and David, we're involved in foundation investments. In Pittsburgh, there's a lot of money here from foundations. They will from time to time invest also in regular companies, but also are subject to limitations, because Cordy will say it's not every time, but that's okay. But from their perspective, it would be good to invest in benefit corporation, because it to the extent it furthers their purpose in life.
So Oded, we have a question in chat.
Sure.
How do you define public benefit? Is, for example, developing a free-to-use search engine like Google a public benefit?
So a public, it's defined in the prior page we had it. I think it's a definition of that actually in the Delaware law. And it's a company that is intended to produce a public benefit. That's item number one. And operate in a sustainable manner. So it's two items that require. Now it's pretty open-ended here. So it can be defined as helping the environment. It can be helping social justice, for example. So it's pretty open-ended. And the operation in a sustainable manner also. It's pretty open, and there's a lot of room for items for this to how to interpret it actually.
Is there a list somewhere or something?
No. When we first did it, our first time we did it, we had it was tough, because how do you do this? How do you define it? It was really our creativity. There's a great source that it's called, and we'll talk about it, B Corps, which is a third-party certification, and they have a lot of list of examples that they use. Stephanie, you may have to add here in this specific topic.
Yeah, I mean, I think some states are more specific in their benefit corporation. They want you to sort of fall into a category, but more and more states are more flexible with what the definition is. So I think the specific example about developing a free search engine, actually, Mozilla Firefox is organized as a social enterprise and I think benefit corporation. So yes, that would qualify under most states. You'd need to look at your relevant state benefit corporation statute, but they're becoming more and more uniform and flexible across the states.
And then we have actually what are the disadvantages, and this is important for any of you who decide to do this. So first of all, don't start with it. Don't think about it if you don't think it's going to be, you're not committed to the cause. That's item number one. Item not because it has a burden, then it's not so simple. David and I, when people come to us, we are really always thinking about the investor side. Will the investor really like it? Is it good? Will it provide the protection that the investor wants? So if you go to a traditional VC, let's say Birchmere in Pittsburgh, I'm not telling, they may have specific interest in specific causes, but in general, their job in life is to maximize profitability. So if you go to them and say, hey, I want to invest in the environment, they would say, great, but I don't want to invest in it. On the other hand, if you think about foundations or the VC that invest in this specific thing, then it's a good advantage for them. But in general, venture capitals would, unless they see a really added value to it, they would prefer not investing in social causes, which can be a side thing, but not the main thing. There is, and Kit, you asked a great question. So how do you find benefit and all this stuff? And I didn't know how to answer it. So that's exactly the legal uncertainty that I was referring to, and people don't really know what it means. What are the implications? There is, I mean, it's beginning much more comprehensive, this thing, but there isn't a lot of case law. And that's why, by the way, we go to Delaware, which has a little bit more certainty, but still there is no case law and there's uncertainty. There is also additional reporting and disclosure requirements, which is doable, but it's still an obstacle, or it's another thing to take care of that the startups don't necessarily want to take care of. And besides that, there's no tax advantage as opposed to other companies. It's the same. It's just regular companies, LLCs or S-Corp. That's it. Just a few words about this, the B Corp, the certification. So that's a third-party certification. It has nothing to do with law. It's like a ISO certification. People will give you, the company or the certifier will tell you, hey, you are hereby certified as a B Corp, and they will do so if you comply with specific requirement and pretty detailed list of requirements, what you need to do in order to comply with their requirements. So it's a marketing tool. It's not anything illegal, but it's a burden by itself. But it's great. I think that Hagen and Ben & Jerry's, for example, are also certified as a B Corp.
So can I be an LLC and get B Corp certification?
So first of all, LLC, you can be typically it requires you to be a benefit entity. A benefit entity can be an LLC and it can be a C Corp. So it doesn't matter if it's an LLC or a corporation, as long as you're registered as a benefit corporation or a benefit LLC in your state of jurisdiction, to the extent the jurisdiction permits it, then you can register as a B certificate.
Okay.
Get the B certificate.
It's also expensive, isn't it?
I don't know about the prices, but you need value. You need really. I'm not sure it's that expensive, but there are a lot of requirements here that you need to comply with. So it's a burdensome thing.
Yeah, I think the pricing is based in some ways on the size of the company. But it's also, as Oded said, it's the other requirements. I mean, it sort of goes into detail, even low flush toilets. I mean, they are really serious about what they view as socially responsible. So, it's a rigorous reporting requirements every year. There are these social impact investors. I mean, in Pittsburgh, it tends to be more the foundations that are playing that role. On an international basis, there are investors who specifically invest to achieve social impact. And it's becoming more common. I mean, BlackRock, which is a pretty substantial financial investment organization, the CEO of BlackRock for the past couple of years has said that you should be investing with a social, at least an environmental mission in line, because if you're not taking environmental sustainability into account in the company that you're investing in, you're going to end up paying the price in the long run. And so there isn't sort of an increasing interest in this movement. I think outside the United States, it's more common. I mean, the United States is for a long time has been a bastion of capitalism, and it's, for-profit, nonprofit should never mix. It's not that way in other countries that are, tend more towards socialism, but it is starting to grow on, I would say, the coasts in the United States. It still hasn't sort of become as popular with investors outside the East and West coasts.
Any questions?
Cool. So, questions. So it says, so even benefit corporations or B corporations fall in the category of, I'll call it, for-profits. So, I mean, even though we are taking into account the other social impact and other considerations, we're still on the for-profit. They're deciding whether they're C Corps or S Corps or limited liability companies. They have owners that we've talked about, shareholders or members. So I'll call that as a subset of the for-profit. I'm going to distinguish that from nonprofits who don't have such owners. The goal is not to create profit for its owners. And so it's a very different animal. So I would argue that benefit corporations are closer to for the for-profit than they are the nonprofit side, but they're a little closer. And with that, let me turn it over to Cordy, who's going to tell us a little bit about the nonprofit world, which is a very different animal altogether.
Thanks, David. Oh, I think you went too far ahead.
Yep. Oh, wait a second.
Wait, missing something?
Maybe I am. Okay. Well,
We're missing one of my slides. All right.
sorry about that.
It's all right. I have it up. I have it open on my computer,
All
so
right,
I'll
cool.
talk about
All
that.
right.
So, yeah, so I'm here to talk about nonprofit corporations. And I guess there's a couple things, first of all, to set the stage. David talked about terminology at the beginning. Nonprofit is a function of state law. And it does not necessarily, that's not a tax designation, right? Tax exemption is a separate concept from being a nonprofit corporation. The other thing I would say is nonprofit doesn't mean you can't make a profit. It means you're limited in what you can do with that profit. Okay, so you can't. So a nonprofit can have excessive revenues over expenses, but the difference is what do you do with that? It doesn't go up to shareholders or owners that we'll talk about. So so just focusing on that state law concept first. What's a nonprofit? Again, some states call it a not-for-profit. Some states call it a non-stock corporation. There's different terms that are used. They all refer to the same monster of the nonprofit corporation. And there's two general structures that you can have. A membership or a non-membership corporation. So a membership corporation is akin to what you saw in the kind of C-Corp world or the LLC, where you have a member. It's akin to a shareholder or a member in the LLC context, except there's no ownership. It's simply a kind of a control relationship where whoever's a member of the entity has the right to elect the directors and approve certain significant transactions. But it's not an ownership interest in the sense that there's dividends or profits that are sent up to the member. You can also have a structure where there are no members at all, and you simply have what's called a self-perpetuating board of directors. It is what it sounds like. The board elects itself. It elects the directors. So there is no membership layer on top. Most states have a separate nonprofit corporation law. Delaware, interestingly, does not. They have their general corporation law and the nonprofit, and they call it non-stock. Their stuff is just kind of mixed in. So it's a little bit, I find it a little cumbersome. This is my practice area. I prefer states that have a separate dedicated nonprofit corporation law. I think it's easier to work with. But you see consistent principles across those various state laws. One is that if you have a membership corporation, those members generally can make capital contributions into the corporation, into the nonprofit corporation, but they can't get them back except when the company dissolves. Okay. There also can be no ongoing dividends or distributions of income to the members or to the directors or officers, although reasonable compensation for services is permitted. Okay. And so then the flip side of this, I said nonprofit and tax exempt are two different concepts. Again, nonprofit is a function of state law. Tax exemption reflects your federal tax status. So you can have a nonprofit corporation can qualify for federal tax exemption, but you can also have a nonprofit corporation that exists without that and is essentially taxed like a C-Corp. Oh, we're missing a bunch of slides here. Okay. All right, so now we'll go back to that slide. Sorry, David, that we already just were. Okay, so what are the general advantages of a nonprofit corporation? Like the other forms of entity that David talked about, you have liability protection from the corporate form, subject to the same kind of piercing the corporate veil concepts that David talked about. Advantages that you can qualify for tax exempt status. If you want to try to avoid tax altogether and you have a proper purpose, if you use that nonprofit corporate form, you can qualify for tax exemption. And along with that, if you're 501c3 organization, you can get tax deductible contributions from donors. The disadvantages of this form of organization is that generally you have to share a lot more control and governance than you would in the for-profit world. As I just talked about, there's limitations on distributions. And there's a lot of restrictions that are associated with tax exempt status. We'll talk about some of them and not all of them today, but just to give you kind of tips of the iceberg. And there generally is more public scrutiny when you have a nonprofit corporation, because people think, okay, you're a nonprofit, you're out there to do good. And so they will look at you with a closer eye. And of course, if you are even tax exempt and you are a charitable organization, on top of that, you also have the IRS and the state attorney general that have oversight over charitable assets. Okay, so next slide. So this is just a quick picture of what a tax exempt organization could be. There are many different types. The ones that people think about most often, I think, are 501c3 organizations. That's the organization where you think, I make a contribution and I get a deduction on my tax return. So that's the group that's on the left side of this slide. And there are many even different categories of 501c3 organizations. We'll touch on this a little bit about what that means, but it can get kind of in the weeds very quickly. There's other type of tax exempt organizations that are out there. Some examples are here on the slide. A social welfare organization, it's a 501c4, a trade association, a 501c6, and social clubs, C7. Those are just a few examples, but we're going to focus on the C3 piece of it here. The next slide. Okay. So what does your purpose have to be to qualify as a 501c3? So the Internal Revenue Code talks about different purposes that can qualify an organization for 501c3 status, and they're listed here: religious, charitable, scientific, testing for public safety. Charitable, by the way, is interpreted pretty broadly. I mean, so stemming from charitable, that can mean relief of the poor and distressed, can mean advancement of education and science, lessening the burdens of government, combating community deterioration, defending human rights. So there's a lot of charitable is a broadly defined term in this list, but just to give you a sense of the different types of purposes. And 501c3 organizations, of all those that were on the prior slide, probably have the most favorable status, because not only you're exempt from federal income tax, but you can also get tax deductible contributions. Those other types of tax exempt organizations do not qualify for charitable deduction. However, the price for that is it has probably the most stringent requirements that apply to different types of tax exempt organizations. Excuse me. And to get that tax exempt status, you actually have to apply to the IRS on what's called a Form 1023. So when you're setting up a nonprofit corporation, you set it up under the state law side, but then you also have to separately apply to the IRS for this tax exempt status. Okay, next slide. So just to give you, if you think back to the chart that was a couple slides ago with the different types of C3 organizations, I just want to talk very quickly about the two broad categories. 501c3 organizations are divided into two broad categories: private foundation and a public charity. Private foundation is the default classification. Unless you can show that you're a public charity, you will be placed in that category. Private foundations are typically supported by a very small number of individuals or corporate donors. They are also subject to much more stringent rules than public charities are. They have to distribute a certain percentage of their income every year. They're restricted in the types of investments they can make, the types of transactions they can enter into with their insiders. So these are typically your grant-making foundations. So that when you think of, we've talked about this a little bit before, I think some people reference this, private foundation money. I mean, that's the folks in this category that are out there making grants to support other charitable organizations or endeavors. But on the other side is public charity. And public charities it kind of denotes it with the name. They are more broadly supported by the public. And because there is theoretically greater public, broader public accountability, the rules are a little less stringent that apply to public charities. But you have to specifically show that you can qualify as one of these types. So there are certain organizations that get that public charity status just by virtue of what they do: a school, a church, a hospital. Others have to show that they satisfy certain tests, financial tests. So one is what you might call a donative organization. It shows that it gets its financial support from a very broad base of the public, from donations. Another category is a gross receipts organization. They receive their revenue primarily from fees for services that are provided in their charitable function. And then there can also be supporting organizations that are organized to specifically support one of those other categories. But the point there is just to kind of keep in mind, if this is a type of organization you're interested in, you do need to be cognizant of how you might qualify as a public charity, because you most likely want to stay out of the private foundation box and all the extra regulation that comes along with it. Okay, next slide. So what does it take generally to qualify as a 501c3 organization? You have to satisfy both an organizational and operational test. And I'm just kind of combine these all together here. The purposes of the organization have to be limited to exempt purposes. So those categories that I showed on a few slides ago. You can engage in a certain amount of non-charitable activities, but it can't be more than an insubstantial part of what you do. And so what's an exempt purpose? So let's use an environmental example. Protect the environment. This is part of what I'm doing. This should be charitable, right? That's doing good for the public. Well, it may or may not be. Sometimes with preserving and protecting the environment, you have to show kind of you're combating that community deterioration or lessening the burdens of government to get in that box. So for example, if you have an organization that this is an easy example, buys land, ecologically significant land to preserve it for the public and open it up as parklands. I mean, that's clearly a public benefit. It's preserving the environment of that space and making it available to the public. On the other hand, there was an IRS ruling that where an organization applied because they were installing solar panels at low and middle income households. And the IRS denied exempt status there because they said there's no broad public benefit here. The impact on the environment is too indirect and tangential, and the primary benefit is going to that select group of homeowners. So you do not qualify as charitable. So it's important to think at the beginning, is what I'm doing or what I'm proposing to do truly in this charitable box. Drink water. The other broad restrictions here are there can be no what's called private inurement, no distribution of earnings to the directors, officers, and members. That's similar to the concept that we talked about under state law. But here, if that exists at all, there's not denial or loss of exemption. 501c3 organizations are not permitted to engage in any political activity, so no involvement or support of political campaigns. And they are limited in the amount of lobbying they can do. And in this context, lobbying means influencing legislation. And the other important point here is that every 501c3 organization has to have in its formation document a dissolution clause that provides that its assets, once it dissolved, will go to another 501c3 organization or will continue to be used for charitable purposes. And that's an important concept here to keep in mind too, because once you have assets that are in a 501c3 charitable organization, those assets are forever committed to charitable purposes. So if you have a charitable organization and you want to sell the assets of it, the board decides it wants to sell the assets, that's okay, as long as they receive fair market value for those assets. And then the proceeds themselves are dedicated to charitable purposes going forward. So this kind of ties to the no private inurement and no dividends up to the members. There has to be a perpetual public purpose for the assets. So the next couple of slides go into a little bit more detail on what this prohibition on private inurement means. There's some examples, excessive salaries, payment of more than fair market value for property, loans to insiders without adequate security or interest, and kind of commingling of the property, free use of the organization's property in a manner different from the public. And if any of those things are done for the benefit of the insiders, the founders, the directors, or officers, that can result in denial or loss of exempt status.
So Cordy, I have a question, and this is actually a David, Stephanie, Odette question. You're talking about disillusionment. So if I'm a startup, we start a lot of startups. We also know a lot of startups fail, or they get to the point where they just want to, quote unquote, get out of business. And comparatively, shutting down a LLC or a C-Corp versus shutting down a nonprofit, what's on a scale of 1 to 10, or how would you weight them?
So I'll start and then maybe Cordy can weigh in. And it goes to the fundamental difference. We are in the for-profit world operating for the benefit of the shareholders or the owners. So we will sell the assets and we'll dissolve the company, and we'll distribute the proceeds to the shareholders, and we'll do subject to the fiduciary duty to the shareholders. We'll do the best we can to get the most we can out of it and shut it down. That's in contrast to the nonprofit, where you have to show that you're getting, presumably you have to make sure those assets are used for the benefit of the organization. So you got to either sell it off or sell it to combine it with another nonprofit, or somehow make sure those proceeds are used for the nonprofit, because the value has to stay with the nonprofit. Right, Cordy?
Right, or to a different nonprofit. You could distribute.
Or a nonprofit.
Right. Different. Yeah.
So I actually think that shutting a nonprofit down is almost harder than a for-profit.
Yeah.
Because you have a regulatory and tax overlay that you don't have in the for-profit world.
Yeah. So for early stage startups, a lot of times you don't have a whole lot of assets. You don't have a lot of stockholders or stakeholders, whatever. So.
Right. I mean, this private enormous, it goes to this whole private enormous thing. If your objective in life is to make money for shareholders, which is, there's nothing wrong with that, and have some ancillary benefits, but that's the principal motive, then, this nonprofit world of Cordy's is not for you. If, on the other hand, you have a altruistic bent to you, you're comfortable with normal compensation, and you're open to, nonprofit may very well be a good way to look, and indeed can attract capital that you otherwise wouldn't be available to you. So whether it be donations that donors can get, charitable contributions, foundations, et cetera, that opens up access to capital to grow your concept and idea in a way that may not be available in the for-profit world. But again, if you're thinking, I'm going to make money someday, and I'm going to sell this, to Google, this world isn't yours. So and some of the limitations that Corey's talking about are sort of the private enormous, all go to the basic concept, which is, thou shalt not do this for the benefit of the individual. It's for the benefit of the organization and for the concept. Now I'll shut up.
Yeah, and that's the price of tax-free operation, right? Basically.
Right.
Yeah.
Right. All right. Keep going.
Okay. Somewhat related to, exactly related to the concept of private enormous is another concept called private benefit. And the difference here is that while private enormous is applied to insiders of the organization, the founders, the directors or the officers, private benefit applies much more broadly. It applies to anyone, and a private benefit can be found where the organization provides more than an incidental benefit to a non-insider. So it can be any of those things we talked about on the private enormous slide, but can also occur if you have a charitable class that's too small. So you may say, well, I'm setting up an organization that's going to provide housing for homeless people, but it's really just focused on maybe a family member or a small group of friends, right? That's a charitable class that's too small. It has to be a very broad class. Private benefit can also incur when a tax-exempt organization enters into a joint venture with a for-profit organization if it's not structured properly. If there are kind of disproportionate benefits that go to the for-profit versus the nonprofit and some other aspects. That can get into a really kind of complicated area. But that's an area where private benefit can occur also. And did we just lose the slides? I don't see them anymore.
I think we lost David.
I think we did too.
Yeah, because I was just. Okay, well, while we're here, can somebody comment on fictitious names? When do you recommend them? Or not? So Oded, you're thinking you're on.
Yeah,
Okay.
Yeah.
sure. So fictitious name is if you want to create a brand or use a name besides your corporate name. It's a simple filing they can do, and you do it on a state level, and you need to make sure that you're able, that name is available, and it's a very simple filing, and you do it with the Secretary of State wherever you do, and you register with a fictitious name. So you keep the same company as is.
Yeah, so it's like $75 or something.
That's very simple. It's not,
Yeah.
it doesn't provide you, the protection. If you really want a brand, you need to register a trademark. If you have a brand that is really important for you. We just had a week ago, one of our clients in a small startup, they sold products and they were sold actually through a third party in England. And suddenly we got a letter from England, hey, you're using our name. So he had a trademark in the US, but apparently there was an issue in London, and they filed a claim against us.
So I'll just say this has nothing to do with legal, but just in general, sometimes they have companies that form with some sort of a name, and then they have a product and they want to do business under the product name. It can be a little confusing to the market sometimes. So there's are you going to create market confusion if you're...
Yeah, I wanted to add one thing to Cordy's presentation, and just a little bit our view, my view, and David's view. If you think about the non-for-profit formation, be very careful when you do that. It's a pretty expensive process from a legal. You need a lot of legal involvement, and it's a commitment. And the fact that you form the company doesn't mean that you'll stay there, because you don't have control about the company. The company is controlled by a board of directors, basically, that doesn't guarantee your continued involvement in the company for the future, because the company is controlled by the board, not by you. You don't own the company. And we had a couple of examples of non-for-profits in the last couple of years. So one of them was a non-for-profit that Stephanie was involved for production of movies in Pittsburgh. Another one that was actually under Kit, I think, Kit's group, was that for growing vegetables in offices or something like that. They had certain systems for watering, whatever it was, and they had a non-for-profit for that. There's another one called Amisero that they do things related to construction of properties or supporting communities, the North Hills and the in distressed areas. So there is a variety, but be very cautious before you do it. It's an undertaking. It's not something simple to get.
So just full disclosure, Stephanie and I usually try to discourage people because they walk in and they say, I want to form a nonprofit, and they're generally not doing it for the right reasons, because they're thinking it's all about, now I can get a grant. There's other ways to accomplish those goals. So reinforcing what Oded said from the business point of view, not just legal, that
yeah, even things, that seem to you very simple, like fighting opioid, a company that developed drugs for treatment of opioid. Even with that context, it's very, very difficult and very challenging and expensive for the client. It was to prove that they are really a 501c3.
okay.
Excellent points. Yes, you did bring me in here just to shoot down everything I do. That's okay. That's all right.
Well, for the types of things we're dealing with.
No, I'm teasing.
But again, if there are businesses that you're in for altruistic, and it does provide access to funding that's not otherwise available. And so there are businesses ideas that lend themselves to that. We have one, Cordy and I are working with that is spinning off out of Pitt. That's going to bring to market some really neat concepts, and they're going to do it as a nonprofit, and they want to give it to the world and have it be self-perpetuating, and it makes a lot of sense for their business model. So so there are times when it makes sense, but as you say, you also say it has to be done for the right reasons.
Yeah.
So it
Exactly
certainly
right.
needs to be considered. Yep. All right, sorry about that. I got kicked out. My internet went down, which I probably screwed up the rest of your presentation. So I apologize for that.
No, it's okay. You know what? I had a couple more slides, but I think we've covered the concepts well enough. And I think I've seen kind of what the time is. I just want to move on. So
Okay.
that's okay.
All right. Questions for Cordy on the nonprofit world? All right, let me go to a couple other items because I know we're going to run short on time. One is, when we form an entity, I want to think a little bit about the roadblocks for the founders. You're going to look around the table, you're going to say who's there with our founders, and so I want to make sure that we've sort of made sure that all the founders have the right to do what we want them to do. So I want to ask a couple questions. One is, are they subject to any non-compete or non-solicit that prohibits them from doing what they want to do, right? If they sign a non-compete where they are, or some kind of obligation, do they have some fiduciary duty to a company that they're already there, right? That's really important. Are they subject to some confidentiality agreement that they're subject, that we should know about, that doesn't permit them to give us the information to the new company that we want them to? Do they have the right to assign the IP to us? And that's really important. For example, so sometimes people come up with ideas while they worked somewhere else for another employee. So, somebody asked me the other day about if they're working in the evening on this project, but they're employed by somebody else. It depends on whether or not they own what they created. Depends on if they're working full time for somebody or even part time. What's the IP policy of that company? If you're working for Google, they may grab what you created if it relates to the same subject matter, even in your basement, right? So you got to look at the intellectual property policy. And indeed, if somebody works for the university, they can be subject to a university IP policy. So perhaps they don't own it, maybe the university does. So you have to create you have to have a license from the university to get the IP, right? So one thing we do when we have the founders look around and look really hard at each other and say, is there any block on our ability to work together to form this company and move it forward? That's step one. I call those the founder roadblocks. And then we ought to think, okay, given that, what are we going to do with the founders moving forward? And you all need to have a pretty firm understanding as who's going to be working with the company going forward. What role are they going to play? Are they going to get paid? Are they not going to get paid? Are they going to work for equity because there's no money in it? Or are they going to be a paid person? Somewhere I need for the work that the founder is going to do going forward, some kind of piece of paper with them in which when they work for the company going forward, they assign the IP related to that going forward. So for example, if you have three inventors, three founders, they're all going to be consultants or do some work, I need some kind of consulting agreement or something that says that what they create while working on the company time or working for the company is owned by the company, that which they create. Short of that, we're going to have a problem because maybe what they created doesn't. We all think that life's going to be perfect and the founders are all going to get along, but sometimes they don't. And if somebody leaves and has assigned one of those, then we have a problem because what they created may not be owned by the company. That's a problem. Similarly, are we going to have our founders sign any kind of confidential? We obviously want everybody to sign confidentiality. They have to agree that what the company confidential information is confidential and that will not be disclosed to third parties and will be used solely for the purposes of the company. Do we want them to sign a non-compete or non-solicit? Do we want the founders to agree that we're not going to go off and run and enter into a competing company? Or they're not going to solicit the employees or the customers of the company. So often we have founders sign those things. It's important. And we can talk about the limitations, et cetera, but the point is, are they going to be subject to those kinds of things? These are all things that when we think about forming, we want to sit around and have those agreements. And then, of course, you get to the question of, okay, so how much is each founder going to get? How are you going to split the pie? And there's a couple things to think about. One is that, understand that there will be dilution down the road. And so, you probably likely take additional capital, you provide some future employees with equity, so you get diluted. So 50% of the company today may not be 50% of the company tomorrow. So think about that as you're doing it. I talk about simple, avoid fancy formulas. I have seen people do some crazy formulas for this, and ultimately it doesn't work out well. So do that. So think about that. If I were to pick one of many mistakes that I've been a part of in the past, it's too many people who have too much equity in the company who have no role going forward. What you want is to make sure you incent people who are going to provide value to the company going forward. So the fact that somebody's done something in the past, it has value, but the point is that we want to incent people going forward to really drive the value. One thing people do is they look around the room and say, well, this is easy. I got 5 founders. There's five founders. I got 100%. This is easy. Each one gets 20%. That may be the answer, but that would be a coincidence. It's unlikely to be the coincidence, because the answer, because it really depends on the value people are providing to the company. And so some people I find it hard to believe that every one of them provides the same amount of value. We'll go through an example in a moment. And then there's the dreaded 50-50. This is great. There's 2 of us. It's going to be 50-50 each of us. Well, that comes with its own set of problems. I mean, who decides at the end of the day? What happens if there's disagreement? How do you, and so what happens if one wants to sell, one doesn't want to sell, one wants to raise capital, one doesn't want to raise capital, one doesn't like the business, one doesn't like the business? How do you make those decisions? So 50-50 is not great. Now, there are ways around this. One is to do what's called a shotgun provision, which says that if it's not working out, or sort of at loggerheads, then somebody throws up a number, and the other one can either buy or sell the company at their interest at that price, and therefore somebody has to be honest. So this is basically a buyout provision. Another thing you do is appoint a third party as a director, so basically acts as an arbitrator, and so they make the decision. I hate to do that because I hate to give this up to somebody else, but you can do that. Or you can actually agree to arbitration. The only place I sort of tend to not get excited about this is if somebody is going to, it's going to be very short term. I mean, you're going to raise capital. You're going to get angel money in fairly quickly. So this is basically a stopgap for a period of time. Then I swallow hard, hold my nose, and get through it. And so I don't get as excited if that's the plan. And we think it's going to be a very short term period of time. How you allocate it is sometimes people go to Demware's Founders Pie Calculator, which will at the next session we'll sort of do it practically. And it is not magic. It gives you an idea. It's not perfect, but it's a pretty good example of how to at least get a ballpark of how to allocate among the founders.
So David, we have a question.
Yeah.
Do you think 5149 solves the shotgun issue?
Yeah, 5149 works because, well, sort of. Why do I always have to add sort of, right? I mean, if you do 5149, then clearly the 51% will have control. And so you avoid my who did what, right? And who gets to decide, if that's what you decide. However, you ought to look at yourselves even harder and say, okay, so I'm the 49%, just because I got 49, does that mean I don't get any choices? So then you're going to start thinking, well, are there certain things this company does that the 49 minority shareholder should have a say over? As an example, should the 51% the shareholder be able to appoint all the directors? Should the 51% shareholder be able to enter into a related party transaction for himself and pay him or herself a big salary? And so what you're going to start doing is building into the 5149 some protections for the 49% shareholder that then will create the roadblocks I was concerned about. So 5149 gets you part of the way, but not all the way. You still have to think about those difficult decisions and how you protect the 49% shareholder.
Well, doesn't that apply even if it's 60-40?
Yes, that's sort of where I'm going. Yes, yeah, but you still got to ask those questions. And if you answered yourself, how am I going to, if you're 41, if the 60-40 is true and you say, okay, short of self-dealing, the 60% shareholder is going to make the decisions, that's cool. That's fine. There's nothing wrong with that. Short of self-dealing, right? But if you're 41, if you're going 51-49 solely to avoid the 50-50, but then I'm not sure you're really going to accomplish it, because you're going to want to do something to protect the 49.
Okay, we've got one more. It's a little
Yeah.
long. When providing equity to a VC for an investment, out of which pool is the equity given?
So, good question. So if we, and it comes out of everybody's pool, is sort of the answer. But let me explain that for a moment. Suppose that Oded and I own a company, and we each own 50-50, and there's 100 shares and we own 50-50. So I have 50 and he has 50. And then we bring in the VC. Well, we're going to issue new shares to the VC. And so that's going to have the effect of diluting both Oded and me. So if we issue 20 new shares, we both have the same percentage, the same shares, but now they constitute less of the company. So when you issue shares to a VC, you're diluting everybody proportionately to their ownership. So it comes out of everybody's hide. Oh,
Well, I think your key there is you're actually issuing new shares, but it
correct.
does dilute it. So it doesn't,
So
although.
it dilutes everybody proportionally.
Okay.
Correct. Yes. Does that?
So you could still have your 50 shares, but it's just less percentage of the company. Correct.
So to take my example further, if I give 20% of the company to a new if Oded and I each own 50-50, and we give 20% to the VC, then although we have the same number of shares, Oded and I are each now going to only own 40%, because we just gave up 20% to the VC. Our 50% became, our 50 shares now became worth less, and so we now own each 40% of the company rather than 50% of the company. Is that cool?
Yeah, it's just simple math.
Yep. But it's a good question, because sometimes people think that one party gives the shares or something. It's newly issued shares from the company. So that's the way that works. I don't want to spend a lot of time on Denver's pie chart. We'll do that next week. But let me just, the idea is to, people give different things: ideas, business plan, domain expertise, commitment, responsibility, etc. And you can weight it, and then you can come up with a percentage. Maybe we'll, Kit, I'm thinking we'll do that in more detail next week before we do the groups. So
yeah, and I'm just going to, we have it on our website, and I'm just going to provide a link for anybody to get in there a little early.
Yep. So that goes to the allocation. I do want to spend one moment, because I do think it's important to remember that we do want founders' equity to vest, at least consider vesting. And what that means is that you have to hang in there with the company in order to have your stock. And so, for example, again, if Kit and I are starting a company, or maybe Kit, Oded and I are starting a company, and we each have a third, even though notwithstanding I said we shouldn't do a third, but let's suppose we did a third. But I want all of our stock to vest over maybe 3-4 years, because it would not be funny for us to form this company and then Kit 2 days later decide, you know what, I really want to go work for Google. And so this is nice, but I don't really want to take this chance anymore. So I'm leaving, I'm going to go for Google. And now Kit owns a third of the company, even though she's gone. That's not funny. So, well, yeah, it's good for Kit, but not so much us. So, and so what we want to do is have it vest over time, so that if she left, a year later, maybe she has some stock, but not all her stock. Okay, that's point one. So vesting over time, or vesting in some fashion, is really important, both with employees when you give that equity, but in addition to founders. That's point one. Point two is sometimes you even say, I'm going to go even further. When Kit leaves, I'm going to buy her stock back at the then fair market, the vested stock at the then fair market value. Because Kit maybe should get the benefit of the value of the stock from when she came into the day she left, but I'm not sure she should hold on to that stock when she goes to Google for forever. Maybe she should give us a right to buy that stock back at the fair market value. So if the company was worth nothing when she came in, it's worth $1 million when she leaves, maybe we should have a right to buy it back for $333,033 before she leaves, and maybe pay it over time because we won't be able to afford it. But then I want to take that third of the stock and I want to give it to somebody else, and to sell it to somebody else, because I'm not sure she should hold on to it when it becomes worth $1 billion when all she did was she was just there for a couple of years. That's something worth thinking about, because the goal is to have as few people on your cap chart who are no longer contributing. That's a thought. So that's something worth considering. So vesting, you can take out your time, 3, 4, 5 years, whatever, to have buyback arrangements, and so think about that. When we're founders, we also want to think about who's going to be on the board, who's going to be managing, who the officer is going to be. We touched on this next one a little bit during this, which is what kinds of things require the board or supermajority member shareholder approval, which is sit around and say to the founders, okay, major decisions, because the majority work, or do we need to protect some minority and have sort of supermajority or larger percentage? So take our example again of Oded, Kit, and me. If we each own a third, maybe really, really, really significant things, it requires 75%. So all of us have to agree on it. I'm not saying that's always the case, but that's worth thinking about. Restriction on transfer, I'm not going to spend a lot of time on, but we all want, I don't care if you're LLC land or C-Corp, you want to have some restrictions on the sale of the stock, because you don't want to wake up someday and have some people in the world owning that stock. You want some limitations on the transfer. So that's that piece. Let me talk for a moment about employee consulting arrangements for our new company, because that's important for startups. And we certainly you typically want at will for employees. You want to be able to fire them when you want. I talked a little bit earlier, but I want to emphasize again the importance of intellectual property assignments. If an employee is doing work, or employee or independent contractor is doing work for the company, it is essential that we have, especially in growth company, IP companies, high IP importance, having what is created for the company assigned to the company. And there's magic language. It has to be assigned today. I hereby assign all IP to the company. I mean, independent contractors aren't necessarily, you can't rely on work for hire. There's lots of nuances, but at the end of the day, it's not funny for a potential independent contractor employee to have some claim on the IP. So it's essential that they have intellectual property assignments. Restricted covenants, you ought to think again whether you want non-competes and non-solicit from employees and independent contractors. Certainly want the NDAs, them to sign non-disclosure agreements. Employee equity. There's a lot of different kinds of employee equity. We're done time-wise here. Oh, cool. There's a lot of different kinds of IP equity, and there's restricted equity. Which is you just giving people. There's options, qualified options, non-qualified options, profit certificate. A couple points here. One is one should talk to the lawyers, because each of these have significant effects, some of which are tax. So there's lots of ways to screw it up, to be blunt. And so giving employees equity is important, but you want to do it right. And so, for example, if you give the very first one, if you give somebody restricted equity, restricted stock, and for example, it vests over a period of time, which is what you want. If absent doing anything else, on each vesting, they'll be subject to tax. So, for example, if Cordy is working for me and I give her stock that vests over 4 years, every time it vests, she's got to pay tax. And of course, as this company gets more valuable, the value goes up, and so she's going to be paying tax. By the way, no cash to pay that tax, but she's got to pay tax. Now, there's a way around that. You file what's called an 83B election. It has to be filed within 30 days after she gets her stock. If she does that within that 30 days, then she doesn't have to pay that tax. The only reason I say that, and I don't expect anybody to walk out of here as an expert in 83B. The point is that when we give employee equity, it's not just as simple as just giving somebody equity. We really need to think through the structure and how to do that in a way that's tax efficient and accomplishes what you're doing.
So David, can I just stop for a 30-second commercial? We're starting to lose some people because
Yep.
we're at our 6:30. Next week is our workshop. Anybody who submits a 1 paragraph, and I'm only talking a couple sentences, descriptions about what your company is, and send it to Stephanie. So it'll help her match up you with some of her law students. She's got 25 of them waiting to give you all this free advice, save you all this money, to give you this roadmap and help you become an informed consumer. But what's our deadline for this, Stephanie? When do you need them by?
Ideally by Friday, but we'll, if you need a little longer, just let me know. I put my email address in the chat, or you can find it easily in the Pitt Law School website. But the sooner you get us to us, the sooner we can match you with a law student who has a particular interest in your company.
Okay, so, all right, commercial's over, Dave.
Oh, that's okay. You know what? I'm pretty well done. I mean, the only thing I want to talk about here quickly is sometimes we talk about the amount of equity to give people. So let me spend, employee equity is not something to be given to everybody. You give to employee equity to that which it's only amount necessary to attract and retain talent. That's the purpose. Don't give it. I don't believe in giving it to everybody. Some people do. I don't. A huge option pool may work against you in evaluation when you raise capital. So don't over allocate. I guess I joke about I'm cheap with equity. You can only give 100% of your company. If you give more than 100% of your company, you go to jail. And as I say, none of us look good in orange jumpsuits or stripes. So I can only have 100% to give. And so you don't want to over give. That both goes to giving too much capital to equity to early money, but also goes to giving too much equity to employees, independent contractors, and consultants. So just a caution. People ask me, as a general rule, people tend to think about what in terms of 15% as an option pool as sort of a rule of thumb. There's absolutely no magic to it, but that's just one way to think about it. With that, I'm done.